All right, good afternoon, everyone, and thank you so much for joining us for today's AAA 2021 Human Resources Update webinar presented by RRR HR consultant Scott Moore. So today we do have folks joining us here on Zoom, as well as both on the AAA's and More EMS Consulting's Facebook pages. So welcome, everyone, and thank you for being with us today. If you do have any questions at any point during today's presentation, please do not hesitate to ask. We're going to ask that everyone joining us live on Zoom, please use that Q&A feature on your menu, as we have disabled the chat feature. And if you're joining us live on either of the two Facebook pages, you can go ahead and comment your questions in the comment section, and we will address them here on Zoom as well. And then just as a reminder, a recording of today's presentation, as well as the PowerPoint slides, will be available tomorrow on the AAA's on-demand webinar page. So be sure to check back with that tomorrow if you'd like to access the recording. With that, we'll go ahead and hand it over to Scott to get us started.
Well, thank you, Meg. I appreciate the intro, and as well for Amanda for managing the Facebook Live on both the AAA site as well as the More EMS Consulting site. I want to thank all of you for joining us. Good morning to you on the West Coast. Good afternoon for those of you everywhere else in the country. This is the first HR webinar, and it feels like the first one we've done in quite a while with last year's craziness with the pandemic. I know we spent a fair amount of time. I think we were in the high 30s or high 40s of webinars that we performed over the course of that year. And while we covered a ton of human resources activity during last year, we had gotten a little bit away from what we traditionally did as our HR webinar series. So this is the first time really since late 2019 that we've updated the AAA's HR manual. So as Meg had said, my name is Scott Moore. I am the AAA's HR and operations consultant. I've been an EMS guy for quite some time. And I know, looking at the Reds list, a little over 100 folks that are joined, that I know many of you, so I can't thank you enough for taking time out of your busy schedules to attend. If I will be keeping an eye on the Q&A, and we'll do my best to answer those questions. If for whatever reason I don't get your question, or your question involves a little more detail and need for me to do a little bit of offline research, which I'm more than happy to do as part of what you pay your membership for, I will make sure that I capture your name and that I get back to you. We do have all the email addresses. So thank you very much for joining. As I always say, trust the lawyer who tells you not to rely on what they're about to tell you, just not to rely on it as legal advice. So just the information in this presentation is really intended for informational purposes only, or educational purposes. If you, it doesn't constitute legal advice. And if you think that you do need legal advice, certainly reach out to a licensed attorney in your area. Plan for today, and this is just a loose suggestion, so we can always go anywhere depending upon where your questions are, but just to talk a little bit about, I was trying to get away from a year-based HR manual and more into an edition-based HR manual, because oftentimes we released the last version in late 2019, and I know as people got into 2020, first of all, the world went crazy, and so it was really challenging for people to try and catch up on things. But it's really, really important, if you haven't done so, that you do so now. I do this for my clients, that I go back and every year we try and tackle a review of their HR manual and their policies and procedures, just to make sure things have a way of changing during the course of the year, and you can end up in a position where you're actually out of compliance, or you may be in compliance in your practice, but your documents look a lot like you aren't in compliance. And really, while many of us have our employees sign off an employee acknowledgement that they've read the policy and procedure manual, we know darn right well that we do that as a legal protective measure. And oftentimes we sort of full well know that not only are our employees not reading the manual, sometimes I'll even find that the supervisors haven't, they'll come in and say, we should have a policy like this. And I say, you're absolutely right. In fact, such a great idea that we've had it now for about 2 or 3 years. So thanks, go back and read the manual. So we're going to talk a little bit about what's in this edition and what's changed. And I will include in there a couple of little HR updates that have occurred around the country, as well as a little bit of heads up on what I've been seeing from around the country with regard to some of the regulatory action. So one of the things I will say before we get started is, if you're not familiar with the AAA's Workforce Committee, chaired by Ben Wasman, and co-chaired by Ron Caranto, I believe. I think I have that right. It's important, and you should always get involved, of course, get involved in the association work, whether it's through committee work. And if you're not sure whether doing association work is right for you, certainly a great place to get started is to jump into some of the committee work. It's a great place to get to know some of the folks and learn what is happening within the association. And frankly, that's where you can make great connections from around the country. So the Workforce Committee did take a look at the HR manual and made some recommendations. And so some of those will be included in this year's edition. So first and foremost, I did send out an article earlier, a blog post last week, just about the updated quarantine guidance from the CDC. So just wanted folks to know that there was or has been updated guidance, which essentially says, look, if you have a fully vaccinated individual or employee who's had both doses, it's been at least 2 weeks after that second dose, and is exposed to someone with COVID within the last 3 months following that last dose, there isn't, as long as they don't have any symptoms, there's no need to quarantine, okay? I have had, though, a lot of folks ask me, geez, are we able to start? A lot of our folks are looking for some sense of what things look like before the pandemic. Can we please, start to loosen up on some of the mask mandates? Can we, is it okay for us maybe to let them not wear masks while in the truck if both people have been vaccinated? While that sounds like a really wonderful idea, the current guidance still is that you are in fact continuing to follow those social distancing, the mask mandates, or any of those preventative measures, as well as many of the states have their own mask mandates, which mean that you still need to abide by the state law. Not to mention, though, that as our folks are out and about driving around and doing things, that the public is viewing our people who are healthcare folks, right, in the front of their ambulance driving down the road. I cannot tell you how many times I have seen this where they are not wearing masks. While I understand that the masks are uncomfortable, I don't care for them myself. You are in a rolling billboard that says, we are healthcare providers. You should follow our example. So what I would suggest is nothing has changed, at least as it relates to those workplace practices relative to being cautious. There also are, by the way, a bunch of various strains that have come out of this illness. And so it's really important, while it seems to be that the vaccination does protect against that, it's really, really, really important that you continue to follow those precautionary measures. So if you haven't seen this article, go on to the AAA's Facebook page, the AAA's website. You'll see that blog post, or it may very well also be on the Facebook page somewhere. In addition, or you can reach out certainly at any time, info@ambulance.org, and you will get one of us so that we can answer those questions for you. So updates to the equal. Now I sort of loosely laid this out in the order that the HR manual is. And this is just a manual that you don't have to necessarily adopt. The idea was, what are those very, very frequently, commonly, or required policies that organizations, in particular ambulance services, should they have in a human resources manual? And so this is really geared towards HR. It's not really geared towards the other areas of clinical or operations or dispatch, communications, education. This is really geared specifically to HR. If you're looking for that other stuff, we often get these inquiries into the AAA, and we will dig and find and ask. Oftentimes there are people more than willing to share their policies. This is just an idea of what it should look like, and what I believe, at least as an employment lawyer, HR consultant, that you should really have within your typical HR manual. So I did make a few changes this year to the EEO policy, specifically related to some changes in state law, as well as some case decisions. In this particular instance, adding some language in there about traits associated with race. So for example, hair texture or hairstyle. Oftentimes there are associations between hair texture and hairstyle, and it would be easy for someone to say, we're going to treat someone different because of their hairstyle. That doesn't matter. If I decided to have a mohawk, right, then that wouldn't necessarily be discriminating on the basis of race. However, there are some hairstyles or hair textures that are associated with the specific protected categories from a racial perspective. And so we wanted to make sure that we're always reflecting what is the most restrictive or the most California typically is where I go to look for what's coming down the path. Usually it's California, then you'll see it in New York, then you'll see it in Massachusetts, and then it starts to spread everywhere else. So I tend to build this to the most restrictive. Why? Because oftentimes when court cases are being decided, they will look to other districts, other jurisdictions, other states, and you do not want to be, while it may not currently be part of your existing state law, you do not want to be the case that the judge or the group of judges decide that we're going to follow the California standard, or that we believe, in fact, these are so inherently related that, in fact, it would be discriminatory. So it's important that you update those policies. Additionally, I added some language in here, as well as in the sexual harassment policy, about encouraging witness reporting as it relates to discriminatory actions, right? One of the things that we know for sure is in organizations where people are encouraged to report harassment or discriminatory behavior, that there is less of it, right? So it's important, and that language has been added, and that really comes directly out of the EEOC's task force on sexual harassment and other forms of harassment. The suggestion that policies encourage people and direct them how to report harassment or discriminatory behavior. Added some practice notes wherever I can. I've added practice notes. And by the way, if you're in a state and there's a practice note that's specific to your state, I try and keep up on all 50. I'm only admitted to practice in Massachusetts, Illinois, and the federal court up here in the Massachusetts area. But what I would say to you is, please, I try to do as much diligence as I can, but what I'd suggest is if there's some practice in your state that you want to make sure others know about, just let me know, and I will, of course, research it. And if it's appropriate, I'll make sure it gets in there. One of the other things that we did in this version of this year's manual include a whole bunch of sample forms that you could use. Oftentimes, we find that people either want something that they can build off of, and where possible, we added, this year we added, I think it's got to be 20 or 30 new forms that were previously not part of the manual, that were created in a way that all you have to do, it's a fillable form, so you can use electronically, or you can plug your logo into it so it looks like your own form, or you can just use it as a reference so that you can build your own form if you want. So updates to the ADA. One of the things that we've seen a lot of lately are a lot of case decisions around, while most folks are pretty straightforward about their obligations when someone comes to them looking for an accommodation or someone with a disability, there really has been a lot of movement lately in trying to, or suggesting that supervisors have an affirmative obligation when they suspect or believe someone needs an accommodation to reach out and actually to engage. So what you should train your folks to do are to be aware, recognize, and spot when someone might need that, and then also to engage your HR professional. So it's important, and sorry, I'm just catching some of the chat. Just to jump back just a minute, says that is also still the OEMS mandate for wearing masks. And this is in the Massachusetts market. I'm sure it is in many other markets as well. So thank you, Andrew, for sharing that. But just important to recognize as we get back to ADA, that really your supervisors, as is almost always the case, your frontline supervisors, those folks who we tend to stick out there with the least amount of training, are actually really critical in trying to help your organization stay compliant. So with those folks, knowing your employees, understanding they will be able to spot these things earlier, because if in fact it was known and you failed to offer or engage that person into the interactive process, you can find yourself in trouble under the ADA. So we added some other language about the reasonable accommodation not impacting, so if someone needs a reasonable accommodation, it shouldn't impact their ability or eligibility to apply for a position, right? The idea behind the reasonable accommodation is that in fact it's reasonable, and it then permits that person to perform the essential functions of the job. So someone needing an accommodation should not necessarily restrict them, provided that accommodation is reasonable. The other thing that I did here was I added several forms. One, there really hasn't been a state where there is a federal form. I included that as in the forms and in part of this toolkit for the HR, the new manual. So the DOL, US DOL is big on a lot of the FMLA forms. There are several though where there isn't exactly a form. So I created a form for reasonable accommodation request, as well as a form for documenting that reasonable accommodation request in that interactive process. In several states around the country, there's a requirement that you're documented the interactive process so that you can really, it's a good practice as a general rule of thumb, so that you can in fact make sure that if in the event that someone ever claims that your organization failed to accommodate their disability, you have a guideline in a consistent manner for tackling these type of requests, right? Consistency is key. When you are not consistent, that is where you tend to fall into a lot of trouble. So this one, I forgot actually that when we released the 2019 manual, they hadn't yet settled on those Fair Labor Standards Act white collar exemption updates. So seems like forever ago. I think it was 4 or 5 years ago, just after I became the HR consultant for the AAA. I think one of my first articles was about these proposed changes to the white collar exemptions, the salary level for the white collar exemptions. That's the professional, administrative, and executive white collar exemptions. That make up the three tests: the salary level test, the duties test, as well as the salary basis test. Sorry, some days are better than others. The original updates to the FLSA, which had not been updated in I think almost 24 years, were pitched by the Obama administration and essentially got kicked around and held up for a long time. Again, in 2019, the Trump administration had made some modifications to the Obama administration updates to the white collar exemption. Finally, as of 2020, those finally did get released. So because we didn't release a 2020 version of the HR manual, I'm making sure that those were included here. Just updating that minimum salary basis of the salary level test is now $684 per week, or $35,000. Formerly, it had been $455, which truthfully, when you think about it, if somebody makes $23,660 a year, or they really a white collar executive, kind of a hard one to pass by. But background screening, I did want to make sure that folks were aware that many states have implemented a ban the box requirement, which essentially means you may not have on your application or inquire about an applicant or a candidate whether they have a criminal background. Now, in some states, for example, the state of Illinois permits certain employers like EMS providers to actually ask that question. In fact, wants them to. And what I say wants them to, wants to make sure that they're not putting potentially, criminal folks with a strong or felony criminal background into or exposed to a vulnerable population. What I'll tell you is that generally speaking, if you think about that hiring process, in reality, the person who answered the question that they had a felony record on your application is far less likely to get a job interview than the person who, if you give them an opportunity to come in and you ask them, and depending upon the state, you can ask either when they're in front of you in an interview, prior to an offer, or depending on some states, you have to have made a contingent offer before you can ask that question. Now, what I'll say is generally, whatever you do, truthfully, you are gonna, if you run a criminal background screening and you find that this person had some criminal record, the idea behind this one was, listen, if somebody did something knuckleheaded, not that any of us ever did anything knuckleheaded back when we were younger, adults legally, but I'm 51, I still don't feel like an adult, you might want to let them have an opportunity to tell you. So if they're 40 something years old applying for a job with you, but when they were 18, they did something stupid, whatever that was, but they have been completely out of trouble since then, should that really impact that person's ability to get a job? It really might depend on the crime. So many of the states have implemented this ban the box. Just wanted to make sure that it was out there so that folks knew you need to stay up to date. One of the things that you can do, there's a great website out there, the NCSL, the National Conference of State Legislatures. You can pretty much plug in there and look, and it will give you a state-by-state list of whatever topic it is that you're searching. So I think that's a great resource. One of the other sample forms that I added, a lot of people get nervous about asking or getting references or giving references. One of the things that I added was this reference check authorization form, which also includes a hold harmless clause, which essentially says, I'm going to permit my employer to give a reference on me. I'm also going to, or I'm going to permit my past employer to give a reference to me, and I'm going to waive any, any right to pursue them for the information that they provide, provided it's truthful. This is one of those things, and this is why most HR people will only verify dates of employment and position only, because they're afraid that someone's going to come after them. Well, the idea behind this authorization form would be that the employee is, or the candidate is informed, listen, I am permitting my past employer to say, to give an honest job reference about, the nature of my employment. Some folks may or may not want to use this. That's up to them. But I figured I would include it so that folks have this. This really is in response, I've been a CAS site reviewer for years. I'm on the panel now. I will tell you, one of the workforce folks said, hey, there should be a policy, and this is required under the CAS standards, current ones, and actually under the new ones that are about to go out for public comment. But the current policy access and changes, that you have a policy in your organization that says, how can people get, where will I find policies, and how will I be notified of changes? It's important that you have this. I know it seems like, geez, well, how are they going to find this policy if in fact the policy access, the policy access policy is in the policy handbook? Generally speaking, what I'm getting at is this idea behind this is, where can you find them if you need them? Usually most people have them electronic. Some people still have them on paper, although that's dangerous. And if we're going to make any changes, how are we going to do those changes, and how will we communicate those changes? Just generally a really good practice. So workplace safety, this one that has come up a lot in this past year because in particular of the pandemic. And it's important that folks know I have seen a ton of OSHA activity. So it is really, really important, right, that you are on top of this. A lot of folks who said to me, geez, I didn't know, prior to the pandemic, there was some lack of clarity in the OSHA regulations relative to N95 filtering face masks, and whether there's a requirement that a medical questionnaire be completed during the fit testing process and reviewed by an occupational health provider. So a ton of lack of clarity in the regulations. What we do know is, though, that if in fact or when a mask becomes mandated use, then that medical questionnaire becomes a mandated requirement. So as you're fit testing for, or actually really technically before the fit testing, you would have them fill out this medical questionnaire. It is right on the OSHA website. If you type in respiratory protection program or medical questionnaire, it'll come right up. This questionnaire is something that you would fill out. It's essentially looking to identify people. Really, my opinion is that this is set for people wearing SCBAs. When I got fitted for my SCBA for the fire department, I had to fill out a questionnaire because those are positive pressure SCBAs. And in fact, for certain folks, they can cause issues or challenges. So, but what we are hearing, and some of this through enforcement action, when OSHA is investigating complaints, they're asking to see those medical questionnaires. If you would ask me a year ago right now, I would have told you that the questionnaire was not required with N95s. But because of what I've seen in enforcement actions, I'm changing that and saying, I would just get the questionnaire done, shoot it by either your organizational medical director, or if you have an occupational health provider, an arrangement with an occupational health provider, just once a month, shoot those forms over to that occupational health provider, let them review them, and they will look to see if anybody's answered that questionnaire in a way that may give you pause and need or require that person to get further evaluated, possibly for a different type of mask, or whether in fact that's the appropriate, whether this is in fact the appropriate, whether you can adequately protect this person. So one of the other things that I'm seeing through a lot of the OSHA actions are this discussion about hazard and risk assessments. So great question, Ellen. How often do OSHA medical questionnaires need to be completed? Those should be completed when you're initially fit testing. And then, by the way, a lot of folks don't know this, but I'd be surprised. And so I don't mean to put this, not only when you initially fit test, but then also when you annually fit test. You are required to conduct an annual fit testing with any employee who's wearing that filtering face mask. All right, so the questionnaire should be filled out each time. How often? Okay, yep. Question came in, if regarding a fit testing questionnaire, what if a state made ordinance that was not what if state made an ordinance that was not required during pandemic? If you as an employer are requiring that N95, and by the way, you are requiring it anytime they are around a patient or a patient suspected. So that would make that required. Even if your state, when your state has a face mask mandate, they're not mandating an N95. They're mandating just a facial covering. So I want to be clear about the distinction there. What we're talking about really are as an OSHA covered employer, whether you're a state or a federal OSHA plan, you are going to be required for your employees who have to wear N95 masks when they are encountering a COVID positive patient or a patient with TB, or any time that you're requiring it, you are required to get that questionnaire. I would have told you a year ago, no, but I will tell you now, because a year ago, even when I was looking through the regulations, it is very, very unclear. They say for respirators, but they are often very deliberate about calling an N95 a filtering face mask, not a respirator. What I will tell you is if you're using one of those elastometric respirators with the replaceable cartridges, hands down, no question, required even before the pandemic. But the filtering face mask and then a typical N95, KN95, any of those, I would say now, based upon what I've seen from OSHA, that you are absolutely required to do that. So the personal protective equipment programs, I have seen some subpoenas from OSHA where they have requested documentation evidencing the annual hazard and risk assessment, evidencing the personal protective equipment programs. This really gets at your bloodborne, airborne pathogens policies. So if those words don't ring a bell with you, then you and I need to be talking right after this webinar. But what I will tell you is if you plug into Google or whatever search engine you use and you type in respiratory protection program or OSHA hazard and risk assessment, you will find plenty of resources that will guide you, really walk you through what you need to do. Sometimes this is more about making sure your documentation is supporting what your organization is doing. I have no doubt that your organization is doing an annual risk and hazard assessment. No doubt. I'm sure you were going around, you probably have a checklist to make sure that your trip hazard signs are there and your fire extinguishers are up to date. But this really comes back to, do you have a written respiratory protection program? What is your airborne pathogens program, as well as what, Ppe hazard assessment. So what this is getting at, and this was part of a subpoena that I saw, the Ppe hazard assessment is following an exposure. Did you do a hazard assessment to determine, was there a failure in PPE? Was there a failure in training? And whether you documented that. And so that respiratory hazard assessment post-exposure as well. So just here's one that I'm going to start working out more on this. This is a really, really recent development. I'd say within the last 2 to 3 weeks that I've been seeing some of this stuff come through, but I just wanted to include it to make sure that you guys were aware. Like I said, if you have questions, please reach out following the webinar, either through the info or through the website, however you want to do it. I will be working some more on these things to get this to be a little more enhanced. Just here are some of those. Oftentimes, we may all have our own work injury form. This is just one that you can use if you want to. It's a sample form. One of the ways in which this is different, in my opinion, than your typical work injury form is I added questions like, okay, how many hours had you been working that day? How many hours you worked that week? And something that tends to be a little bit different for public safety folks, how many hours have you worked for any other employer in that week? Because how often do you find that your folks are running from one job to the next? So this was really one that I geared and have used over the years when I have been managing organizations. Not only that, but also a supervisor in work-related injury investigation sheet. I cannot emphasize enough for you how important it is when you find out that your employee has been injured, that you are having someone conduct an investigation. It's also a great way, by the way, to exercise your supervisors in the practice of conducting workplace investigations. It's been a couple of years since we did the Supervisor Sim Lab on investigations, and I cannot wait to get back to those. But what I would suggest is the form is really designed to walk them through what they should be asking about. In addition to that, I added an employee light or alternative duty form. This is typically a form that you might give to the employee to take with them to the OC Health or wherever they tend to go, right? ED is generally not the right place for an employee, unless the only one time I say to send someone to an ED, really, unless it's a really, really serious emergency. But the one time I say is if someone has an exposure, either a stick, a needle stick, or some other exposure, that person should get evaluated at the same hospital that the patient went to, so that the infection control officer at that hospital can stay connected. Outside of that, and if as long as it's not a really true emergency, most of these folks belong at either an occupational health center or an other urgent care. That's really, frankly, the more cost-effective place. You can also enter relationships with those folks to talk to them and explain to them why and what, that your organization may, for example, have a light duty program that you want, or alternative duty program. The one thing that I will say about light or alternative duty programs that a lot of people haven't considered, there's been a lot of action lately. If you offer light or alternative duty to your individuals who have been hurt at work, you need to know there have been actually one ambulance case and then a whole bunch of other cases that if you have employees who, for example, are pregnant, you will likely have to provide them with the same light or alternative duty that you offer work-related injuries, right? Because they're similarly situated. And the only reason that you might not offer it, in the old days, we did this all the time. We'd say, oh, no, light duty is just for work-related injuries. You cannot do that any longer. Plenty of case law. Happy to talk to folks offline about this. But what I'd suggest, and some people have said, we're getting rid of all our alternative duty programs. That is certainly an option. I still don't think in the long run that makes a whole bunch of sense, because really keep in mind the most expensive part of your workers' comp claim tends to be the portion related to the employee's wages. So the sooner you get that employee re-engaged for a whole bunch of reasons, generally speaking, the shorter those claims tend to be and the less expensive those claims tend to be. So keeping an eye on the questions. I haven't seen a bunch come up, but I'll keep rocking and rolling given the time. So immunizations, vaccinations, brand new policy, did not have it prior to this. Frankly, probably should have, because we have been dealing with influenza and vaccinations for a long time. A lot of folks asked over this past year, can we mandate vaccinations? And the answer, short answer for the most part, is yes, you can. Of course, you need to consider the fact that someone who has a disability or a medical condition where the vaccination is actually contraindicated, or a religious objection, based upon that the vaccination would run afoul of their sincerely held religious beliefs. Those are going to probably be generally the minority. I would say you're not going to see that a ton. But the whole mandated vaccination thing is an incredibly polarizing question. And what I would say first is, a lot of people early on were saying, will you get it or won't you get it? That's probably not the best question to ask. The best question to ask is, will you get it? Yes or no? Will you get it with more information? Yes or no? Or, find, as I sort of said before, seek first to understand why people are on the fence about getting the vaccination, in particular for coronavirus. Lots of places have been mandating influenza for a very long time. And these other tests are stuff that generally were required for folks to enter school systems, et cetera, or college. So what I would suggest to you is this really isn't all that different. I did create some new forms for this related to not only a policy that's in there, of course, that's in the back there, and then two forms. One is the vaccination form for COVID. The other one is Hep B. Hep B has been around for a while. Yes, I want it, or no, I don't want it, because why? Well, I don't want it. Why? I don't want it because I've already had it. So you want to find out. And same thing with COVID. I put in there even a question of, I don't like needles, right? If that is, I have a brother-in-law who kibbies out every single time they try and take blood or give him a needle. And I said, Dave, why aren't you going to get the vaccination? He said, I'm waiting till the one needle vaccination comes out. So I don't kibby out twice. I only kibby out once. I get it, right? That's an important thing to understand. So it may very well be that some of your employees don't like needles, despite the fact that some of them may be actually administering IVs. Find out, seek first to understand. I'd appreciate more information on light duty, offering light duty to E's who had work-related injuries. Did you say we can no longer do that? Or if we offer light duty, we have to, all right, so great question. So just a quick, I'll cover it one again, and certainly happy to talk offline. If your organization offers light or alternative duty to folks who have been injured at work, okay, if this is a practice, and I recommend that folks do that. Why? Because it is a way to keep your employee engaged. It's also a way to it has to be legitimate work that needs to be performed, but it keeps folks engaged, right? Sort of Newton's first law, an object at rest will stay at rest unless acted upon by an outside force. What I say is keep them engaged. You certainly don't want them sitting at home watching Springer. and they don't really want to be home watching Springer. They'd rather be earning money. So what I would say is keep them engaged. But if you offer light duty to an employee who has a work-related injury, and then you have an employee who comes forth and has a restriction because of their pregnancy, you are going to have to offer light duty to that individual as well. If you don't, you will be running afoul of the ADA. So yes, that's what I'm saying. That has been really developed over the last year and a half. And so now what I'm telling folks are just be prepared, right? You are offering it to similarly situated individuals. But happy to talk offline about that some more, after the webinar, anytime, just let me know. And maybe we did do a session on this at annual last year, our virtual annual, and I think that session is probably still available. It was one of the quick takes, like 20-minute long session. So be more than happy to either, I'm sure AAA can hook you up with that, as well as more than happy to talk offline on that. So drug and alcohol use. This is one that probably should say substance use. Is that just for pregnancy or other injuries as well? That's a great question, Chief. What I will tell you is that remains to be unseen. So if you have someone who goes out and skis and blows out their ACL like I did when I was 25 years old, do I have to offer that person light duty? I have to say, I think that will largely depend. What I suggest is that you are consistent. With pregnancy, if the only reason that you're not offering that light duty is because it's not a work-related injury and what the person is suggesting is pregnancy, well, then that really is making that decision based upon that person's gender and that person's pregnant condition. If you're not offering it, let's say, to someone because they were doing something like a risky behavior, they're skydiving, whatever, and they blow out their ACL, and the reason that you're not offering is because they were not because of their gender, not because of some other protected category. You were not offering it because they were doing risky behavior. Well, then I would say you're perfectly fine, because let's play this one out. If I blew out my ACL skiing and I come into you and say, Chief, I want light duty. Why? Because I went skiing, blew out my ACL, I'm down for 9 months. You could say, no. And would I walk into the EEOC and say, I have been discriminated against because I went skiing and blew up my ACL. But what you must be really, really cautious of are individuals who went skiing and belong to some other protected category. So just be conscious of what your rules are, right? And make sure that you're clear and consistent in your application. I hope that answers that, Chief. I can always circle back around with you after. So this is one that was a little bit of an epiphany for me, because I know, right, like 35 states in the country, I think it's all but 4, have some legalized form of marijuana or CBD. All right, whether it's medical, recreational, or just the CBD, the marijuana related products. I think there's 3 or 4 states that don't have it. What I would suggest to you, by the way, is the legalization is not the determining factor as to whether your employees are using marijuana related products. Sorry to break the news to you. What I will tell you is you need to be super clear in your policy about drug and alcohol use or substance use. What I will say is, even if you are in a state where marijuana is legalized either medically and or recreationally, and you are a federal contractor or a federal grantee, so you received a grant of any amount, or you have a federal contract of $50,000 a year or more, you must maintain a drug-free workplace, right? That is under the Drug-Free Workplace Act of 1988. So you must maintain a drug-free workplace. You do not have an option, right? People cannot use weed, even though everybody's doing it. It's all the rage, right? I used to think it was people hanging out in their parents' basement with their velour blacklight Cobra poster, but turns out actually it's pretty prevalent. And what I would suggest to you is be clear. This is not the policy that you want someone going, oh, I don't really know what our company's position is. Make sure that if you walked up to any employee in your organization and said, what's our position on marijuana use? You want your people to know. Now, also know if you're not a federal contractor or a grantee, but your people are in safety sensitive positions, which EMS is included in that safety sensitive position, right? They're operating vehicles, they're taking care of patients. Included in that, in my opinion, are dispatchers. What I would say is anybody in a safety sensitive position, fleet mechanics, cannot utilize marijuana in any form or fashion, even in a state where it's legalized. Recognize that, all right? The only thing that I will caution you about is if you have a person who's not in a safety sensitive position and you are in a state where medical marijuana is approved, you should be very, very cautious about that instance, because someone not in a safety sensitive position, If you're not a federal contractor, not in a safety sensitive position, that person has the legal right to use marijuana, just does. Now, that doesn't mean your organization can't have a no drug policy. What I would suggest is you just need to understand, if that person tests positive and they in fact have a recognized disability, then you need to go through the interactive process. That being said, right, you can go to that person and say, listen, we don't allow the use of marijuana here. I have to tell you, my belief is you're going to have to permit it. Now, that doesn't mean that you couldn't engage that person and say, look, there are, whatever the medical condition, you could send a note to that doctor and say, listen, doctor, by the way, I want to be clear, people don't get prescribed marijuana. Marijuana is, cannot still to this day walk into CVS and go, yep, give me that marijuana, I need it. It's not regulated by the FDA. So no one gets prescribed it, they get qualified. Qualified is something different. When someone goes to fill marijuana, right, do they go to a pharmacy? They do not. They go to a dispensary. Very, very different. Imagine if there were opioid dispensaries, right, where anything can gotta go. That's not the way it works. You have to go to a pharmacy for FDA regulated drugs. What I would suggest is here, anybody who tells you I've been prescribed, you can correct them and say you've been qualified. You've not been prescribed. Semantics, but it matters. What I would say is we have a drug-free workplace here. And even if you're not a federal contractor, is there another medication that you could use that takes or resolves that issue that you have? Marijuana has been proven or shown, well, according to the FDA, there is no medical reason to use marijuana, no beneficial use. I hear from a lot of folks that's different. I can't answer, but what I will suggest is you should go through the interactive process with that individual if they're in a non-safety sensitive position. Outside of that, if they're in a safety sensitive position, your position can be firm and strong. Absolutely not. What I will tell you is I added a note or added a section about marijuana, and I'd love to say cannabidiol. I can never say the word. It's marijuana related products, CBD. A lot of people talk about CBD oils, CBD creams, stuff that help with pain and discomfort. What I will suggest you, again, not regulated by the FDA. So what does that mean? When you go to wherever you're buying these products, what is marked on that product does not have to be accurate or may not be accurate, right? So recognize that any CBD product that has 0.3% of THC, which is that active, psychotropic ingredient in CBD oil, right? If it's more than 0.3, that person can test positive for marijuana. They could be looking at you square in the face and saying, I'm not smoking weed. I'm not doing edibles. I'm just using CBD oil. Your folks need to know if they test positive, and especially in a drug-free workplace or a safety sensitive position, that can impact their employment. And they need to know that. But even though that product may say 0.2 of THC, it could actually have 0.3 and could test positive. So important that you know that. All right. And I see that question. I just got a quick, what if light duty is not an option, such as a paramedic that becomes pregnant? Well, I'm not really sure what that means. And forgive me, if you have a paramedic who fell down a flight of stairs while doing an extrication with a patient, and you made light duty available to that paramedic who fell down a flight of stairs, legit injured, right, at work-related injury, and you make light duty available to that paramedic, you must also make light duty available to the paramedic who's pregnant. That's just the way it goes. I hate to tell you. It's one that a lot of people struggle with, but I'm happy to talk more about it offline. Are PPPs considered a form of federal grant in any way? As much as I try and get away from, I try and do the HR stuff, I keep getting pulled back into the PPP stuff. I'm kidding. I actually like that stuff too. PPP loans are not considered federal grant. Great question. It is a small business loan. And I know we've talked about them being the equivalent to a grant, a tax-free grant. I think actually that's probably a question worth chasing down just to make sure that in no case from a drug-free workplace, that's actually, Joe, that's a great question. I will chase that one down and I'll get back to you. Can you tell someone that is qualified for medical marijuana by their medical provider that they do not take marijuana in medical legal state Can you tell someone that is qualified for medical marijuana by their medical provider that they cannot take marijuana in a medical marijuana legal state in a non-safety sensitive position? So I'm not sure, Care, if this question came in before I went through that process, but I will say is this. if you're in a state where medical marijuana is legal, your person's in a non-safety sensitive position, you are certainly permitted to have a policy where you don't want your folks using drugs. But what I will tell you is tread very, very, very lightly. In other words, you could go to that employee and say, listen, marijuana just is a problem for us, and we have a position where we don't want our employees using marijuana. You could go through the process where you say, look, is there anything else that you could take that might resolve? Because there are tons of medications that resolve many of the common, there are some that I'm told this is the only thing that works. And by the way, if this is the only thing that works, the question you have to ask yourself is, well, what harm do I suffer if this person is technically under, and the problem is testing for any of really impedance. There really is no recognized way to test for being under the influence of marijuana. There is something called the DRE, a drug recognition expert. It's been, some courts have recognized that generally these are law enforcement officers who also have been trained in the field sobriety techniques. I looked at trying to get into one of the classes. A guy that couple cities over, used to be a drug expert here in the Boston area, was running the course, and I tried to get in pre-pandemic, and they only offer a few spots. Now, I couldn't become a certified DRE, but I could at least audit the course and attend it. That's one of the things that you could certainly do. But what I would say is, if in fact you have a person who is in a non-safety sensitive position and is using marijuana, you certainly could engage them, but I would tell you, tread very, very lightly. What about the timeline for 30 days of marijuana being in the system versus IRA? So I will tell you that I did a little bit of research, and by no means am I an expert on weed, but what I will tell you is this. Anybody who says they test positive, and you go, listen, you've tested positive for weed. I recommend, by the way, using an MRO, a medical review officer, which is usually a service that you pay for with your drug testing lab, that essentially leaves you out of the equation. If the test comes back non-negative, it's important to understand, non-negative means it's not negative. I know it seems crazy. The MRO will call that person and say, is there a reason, for example, if you're on ADHD medication, why are you testing positive for amphetamine? Now, it may very well be a perfectly legal reason. The medication is being taken consistent with a prescription. That MRO finds that out, confirms that, and then the test result back to you is negative. Why do you want that? Because, of course, once you know someone's taking a medication, that can lead you to know about things that might be protected disabilities. So you don't want to know that. Use an MRO. But what I will say is, if you have someone who says, yeah, I know I tested positive, but it was just one time, I took 2 hits, and it was what we know about the way marijuana is digested or processed through your body. If you are a once in a while, like once a month, you take a couple of hits off a joint, you are likely going to test clean within a couple of days. But if you're a wake and baker, right, like alarm clock goes off and you are on that pipe before you even know what's going on, or you're popping gummies, and this is something you're constantly doing, it takes greater than 30 days for that to get out of your system. So if you are a regular habitual user of marijuana, it takes a very long time for that to clear out of your system. So I hope that answers the question, Mike. What do you suggest if you see an employee enter a dispensary and come out? Would we be permitted to test them? That's just an awesome question. I love that. If you're like, wow, awkward meeting you here, how's it going? Anyways, love that question. Yes, if you happen to actually see, it blows my mind what people put on social media, but what I will tell you is you can in fact address the behavior of people who are doing things like you bump into them coming out of a dispensary. Now, by the way, they may have just gone in there with someone who was using marijuana, not them. So you would probably want to talk to them first and go like, hey, now if it's just them, different thing. Maybe they dropped their friend off and walked them in, right? Who knows? What I would say is go through that process and find out. But yes, you certainly, we see people all the time, right, who are posting things on social media. You can question your people about social media. In fact, we'll get to that policy in just a moment. All really great questions. So hazard pay, on the compensation policy, I added something on hazard pay just because so many places, so many states, so many other folks decided to do hazard pay. Just recognize that, in fact, that impacts the weighted average overtime. If you're not paying it all of the time, you're just paying it for some shifts, or you're paying a differential functionally, make sure you are understanding the impact to the overtime calculation. You have to use what's called a weighted average overtime calculation. Recognize, please, that your payroll software may or may not be calculating that correctly. I have found, and did find a couple of years ago, several of the payroll vendors, their calculations were wrong. So you'd call up and say, we got to do a differential, we got to do a bonus. You recognize the person who set you up there doesn't necessarily understand what happens in the background of the implications of the Fair Labor Standards Act on the calculation. So you have to test it. The state of Texas has a great weighted average overtime calculator that you can plug in some numbers and it will spit out what it should be. Certainly test it. That's all I'll tell you. I ended up on the phone with a couple of the large payroll companies and their attorneys and all that nonsense, and basically proved to them you're calculating it wrong. And I've been told just the other day from a AAA member who said they're still kind of calculating it wrong. So just make sure you were looking at that. There are several total compensation statements listed. These are just things, this is a nice way to let your folks know, hey, this is what really we pay you. Because a lot of times all they see is what ends up in their check, in their checking account or the bank account. A total compensation statement is a really good idea. It does let your folks know exactly how much it costs to employ them. And that is something that oftentimes we don't see people taking advantage of. So paid time off, I did add, and there are several forms in here about the emergency leaves, which of course, employers are welcome to continue through the end of the first quarter. I will, remains to be seen whether they'll continue this past that first quarter, but you had the option to offer this. You were not required if you're an EMS provider, but just we did add some sample forms in there. Those we put out last year, just, not only an exclusion notice to say, hey, we're not providing that to our employees. I recommend that you notify them. But by the way, this horse is kind of already at the barn. So hopefully that's not an issue. So attendance and punctuality, I just wanted to let folks know, one thing that I have seen more frequently, and there is a federal law on this for federal employees, but a lot of states more recently have been passing laws relative to time off, paid or unpaid time off for organ donation. Some of them as long as 30 days, some of them just 5 days for bone marrow. What I would suggest, and this was a website that I found that actually had kind of a listing of those donor laws by state. What I would suggest is you take a peek just to see where you are. If your state's on here, by the way, there is a law relative to employer required leave of some kind. So, and I went through and I thought I grabbed them all, but just confirm, that's a good place to check. All right, social media. This past year was a son of a gun with social media and all of the, social unrest and the rioting and so forth. What I would tell you is I've heard a lot of people who I have a First Amendment right to post whatever I want. And that just honestly is hogwash. Well, you have a right. It just doesn't mean that you can stay employed. What I will tell you is you can put whatever you want, right? That just your employer may take action based upon what you put. So for example, if your employer saw you out at one of those protests or riots and you're not wearing a mask, following social distance, they can take action upon you for that. What I did put in there was just added language saying that your decision to post social media content on platforms may impact the public's trust. Oftentimes there were a lot of posts over this past year, stories over this past year, where people said stuff that, as you think about the role that an EMS practitioner has, a huge public trust issue there. And if you're posting stuff that's hateful, angry, or hate speech, honestly, employer has a right to take action. So I added that in because, right, presumably your employees can see this. Wait a minute, what? They can, if I post something, it can impact my employment. I didn't know that. And by the way, they're still going to say that even if they sign the acknowledgement. Why? Because we know they probably didn't read it. I used to work with a guy who used to make us go through at least 2 or 3 policies every single supervisor meeting. Why? To make sure the supervisors knew about the policies so they could talk about them. All right. That's a good practice too. Appearance and hygiene, formerly I said uniform. Actually, it was formerly dress code. I looked it up. Made some changes, PPE. When we had the pandemic and everybody had to start wearing masks, a lot of people were really mad because they had that Mac Daddy Zach Brown beard that they did not want to get rid of. And what I used to think when I'd see people driving on the street with big beards, I go how do they make that? How do they make a seal with a mask? Right. And the problem with qualitative is I get to tell you whether I taste it. Now all that saccharin could be in my mouth and I'd be like, nope, nothing. And you would have met your standard. But what I will tell you is it has to be reasonable. So we added some language about facial hair. We also added language about fingernails. There are some whack job fingernails out there. And what I will say is that is one of the places where bacteria, and in this day and age of handy wipes and hand sanitizer, et cetera, that was something that did come up that we wanted to make sure that folks understood those considerations. I will say be cautious of facial hair and EEO considerations, right? There are certain religions that require or permit certain facial hair or other practices that impact appearance or hygiene, even getting back to that EEO hairstyles, right? That can be associated with race. Just be cautious in what you do. Be cautious. Happy to talk offline. So already talked about those light duty assignments, so I will bounce past here. Added several forms, so that you certainly can just use them if you want, but don't if you don't want, or use them as a good starting point. FMLA, we added in all of the federal previously provided federal documents, right? DOL put out a lot of documents relative to the Family Medical Leave Act. What I will tell you is they never added anything about they never added a form to request family medical leave. So I created one. Also, I created a checklist that employers really should follow, just so that you are consistent. What you don't want, and I've had this in the past, clients who have gotten the request from the Department of Labor to produce a list of every person who's requested leave for any reason over the prior 36 months, what that request was for, how you responded to that request, and whether you granted that leave or not. You do not want to have to pull all that information and then have it be all haywire all over the place. Get consistent in your practice, and hopefully you're logging those requests as well, so you don't have to go looking through people's folder to try and find that stuff. And then this is really the last change that was made. I just added a note that many states have put in or passed domestic violence leaves to protect folks who are the victims of domestic violence. This is one that's long overdue. Just, if you don't already have this in your state because it's not required, you should probably have something that permits your folks. For whatever reason, the last thing you want is someone who is in a domestic violence situation worried about losing their job if they don't come to work, right? So just take a peek at your state, make sure that your state either has or has not, and that you're in fact abiding by those notice requirements. And if you're not sure, certainly reach out to the AAA. We're more than happy to answer that. So I think I've hit every question. This year, the manual can be downloaded where you can in a Word format or in a PDF format, so you can just plug your own information. I suggest it's careful, it's not a one size fit all. So you should, if you're looking for a good place to start, this might be a great place to start. And then you go back through and look, don't do a save as, like find and replace. That gets dangerous. I've seen that in patient trip records, and you're like, wow, this is a 27-year-old male when there's a 6-year-old female sitting in front of you. You're like, oh, okay. So what I would suggest to you is have your counsel look at it and make sure. Early in the webinar, you mentioned that hard copy of employee manuals are dangerous. Please explain why. Great, we do have time. So the problem with hard copies are we really stink at making sure they stay updated. The great thing about electronic versions are you can change a policy, send out an electronic notice to folks, and then keep that in one place. You don't have to then go, did we get to station 12? I don't know if we got to station 12. We got to make sure we get this paper copy over station 12. The other thing can happen in hard copies are, I don't know if this happens at any of your stations, but someone pulls the page out, throws it away, or what you don't want is for someone to go to a paper is just, it's asking for a problem. So I just suggest that you have it. If you have it in paper, also have it electronically, right? Make it easy. By the way, I don't know if you know this, my kids laugh at me when I talk about Facebook. They think I'm old. They say only old people are on Facebook. And if I even pulled out a newspaper, they would probably laugh at me. So great question. Is it sufficient to have labor posters on your website since PDF? So the answer to this is actually, that's a great question. I'm glad you asked. You must have it even if you offer it electronically. If you have a work location, it must also be in the work location. That is a requirement that has been answered specifically. But I do think, given the latest activity relative to people working from home, that electronic is also a great place, but that does not excuse your obligation to post the hard copy. So Robert, great question. Scott, thank you as well for your question. Certainly happy to talk offline about any of those. But with that, what I will say is certainly all of those resources, I know Amanda plugged in the Dropbox so that you can just pull that stuff down all on your own. Certainly in the meantime, if you have any questions, certainly you can email me, you can type in info@ambulance.org, that'll come through, or you can do the hello@ambulance.org. I think that's what that says up there in the chat. Yep, hello@ambulance.org, and we will be happy to respond to that. as for all of you, I know your time's valuable. I can't thank you enough. I hope this was worthwhile. And so if you get sent the survey, please, please, please fill it out, because I want to get better at this if I can. So last question, if there are any simple programs for tracking, I will tell you, great question. A lot of people just do it in a spreadsheet, believe it or not, but we can talk, Andrew, offline. I'll reach out to you. I did have an idea relative to that I'd love to run by and see if you think it's worthwhile. So folks, 3 o'clock, top of the hour. I can't thank you enough. I don't know if I think I've hit all of the questions, so I appreciate your time and welcome any feedback that you have or any other questions that are out there. Please don't hesitate to ask. So with that, I will hand it back to Meg to close us out.
Thank you again, Scott, for today's presentation. And thanks to all of you for joining us. The archive link to the recorded session is available now on Facebook. You can actually launch Facebook Live at your convenience. Additionally, the YouTube recording link will be emailed out in tomorrow's Daily Digest member email. Thanks again for joining us and have a great day.